case entitled, in the matter of the estate of Robert J. Kerner. It's case number 2023 PR 123. Beginning with the lawyer for the co-executors, would counsel announce all appearances for the record, please?
Yes, Your Honor. Lisa Machikow and Jenica Nelson appearing for Kyle Corner and Christy Garens, who are the court-appointed co-executors using the last will and testament of the decedent.
Yes, Your Honor. Austin Parker for one of the beneficiaries under the will, Whitney Corner, as well as claim for under the petition for family allowance and spousal allowance, Miss Helen Corner. Thank you, Your Honor.
So Helen participates with audio only, Whitney with both audio and video. This matter comes before the court at this time for hearing on a petition for final settlement and approval of a valid settlement agreement. Ms. Machikow, I presume that you're just asking for approval today, correct? And I'll expand on that here in just a little bit. But Mr. Parker, from you and your client's perspective, is there any objection to this court granting the petition for final settlement as submitted to the court?
Yes, Your Honor. Not the actual settlement agreement. I have signatures held in escrow for from both Helen and Whitney concerning the actual finals valid settlement agreement that discussed the appropriation of what was agreed to in terms of value to Helen. Okay, for the allowances, the homestead allowance and then the spousal family allowance. Both of those figures have been agreed to. The real question is there was a and I was optimistic originally about this, Your Honor, but there was a attempt to go on ahead and try to come up with even the need for this hearing to do the final accounting for the estate. That's really where the questions come in. So the signature are held in escrow out of an abundance of caution because there was some language that, hey, we're not disputing any of the. I didn't think it went this far, but there was a question from my clients about are we able to ask some questions during the final accounting because we don't understand where some of the things, particularly with how many hours were worked by the co-executors of the estate. There's not really a description of what they did, just some time for it, and we're not exactly sure how all that adds up. So that was one of the questions, and then also exactly on the final accounting where some of the assets that were sold over and above the mobile home park. Those were the two main questions that were on it. But by signing the final settlement agreement, they didn't want to remove their ability to ask those questions at the final accounting. So the signature held, the settlement agreement, my clients are in agreement with those allocations for, again, for what Helen is to receive. It's really the questions are relative to the final accounting, if that makes sense, Your Honor.
Well, I think it does. Is there an itemized listing of the time spent, what it was spent doing?
Your Honor, I don't want to speak on behalf of opposing counsel, but if you look here, they've provided some printout lists of time work. I would be happy if I could share my screen, Your Honor.
You may do so.
Thank you, Your Honor. I'll just use an example here. This is some of the hours that were worked.
Watch as the court sets the stage for a legal showdown.
So, and these are recorded hours. So they record what the hours were, and then they bill at a $50 per hour rate. 7.68 hours here, 1.02 hours, 0.48. This was produced to us here in the last, I would say 60 days. Okay, so this is for that month of April. So in the month of April, there were two people. This is for April 2024. There were two people, and this is Kyle also as well. 41.88 hours from him at $50 an hour. This is just an example of what the breakdown looked. And this was generated October 6, 2024, from what I can see here. So you have that 41.88 hours. And then if you go up here, 33.68 hours. So this is better than 75 hours managing a 20 lot mobile home park where they hired someone else at $10 an hour to do the mowing. So what I'm trying to, and that's at least my understanding, what I'm trying to figure out is,
Your Honor, I'm
what
gonna
did
have
they
to
spend
object at this
75
point.
hours doing that?
That's just not truthful. It's not even what's been presented in the final settlement petition. If it's clearly stated, it's $35 an hour.
Okay, well,
They
I,
ran this mobile home park for a year and a half. It wasn't cash flowing when it was the decedent's business. It cash flowed significantly now.
Yeah,
But,
Mr.
and
Parker, I
that's
think,
all been
just a
previously
moment, counsel. Just a moment. Mr. Parker, yeah, the petition for final settlement seeks a reimbursement rate of $35 an hour, and so they're bound by that.
yes, Your Honor, I have no objection with the hourly rate at 35. Quite frankly, even if they were at 50, although I would question that, I'm more interested in what did they do for 75 hours in the month of April to manage a 20-lot mobile home park. And in here, the hours, they say 1.6, 7.68, 2.3. There's like, if I build like this, they don't have any code for what they did. They just said, I did 7.68 hours of work, and I don't know what that is. And I don't expect them to be able to go back at this late date and say, this is what I did on this date in April. I'm just saying logistically, I'm not trying to get into their business. I'm just saying, I don't know how you spend 75 hours collecting rent from 20 people in a mobile home park. I don't understand that. And that's really where my clients are coming from. They don't understand how could you spend 41 hours a month running a mobile home park?
Is there a
If-
response?
Absolutely, Your Honor. So back in the middle of early February, an itemized task list was provided to counsel, Mr. Parker. And this is an operation that went on for a year and a half before they were able to effectively sell the mobile home and the business of operating it. There are 20 manufactured homes that sit on the site, with about 3 of them being tenant owned. The rest are owned by the mobile home park. There's common grounds. There's a lot of repairs and maintenance. One trailer had a hole in the floor where a family of raccoons was coming through, and to coordinate all of that work, not to mention they only had a property manager for the month of August. The rest of the time, it's been Christy and Kyle actively managing this property so that they could collect back rent owed, that they could actually get rent paid in a timely fashion. And then they've been able to make this business cash flow to the tune of about over $100,000 over the year and a half that they've been operating it. Where if you review the tax returns, which were also provided, and this background information was also provided to Mr. Parker, that it was running at a deficit and not cash flowing year over year. At least I think we provided 5 years of the tax, 3 years of the tax returns before decedent passed. So this was not just a rent collection where you send timely rent payments in the mail. This was a hands-on, a lot of repairs and maintenance had to be done even on the common ground, where Kyle Corner actually fell and broke his leg doing some of this work to try and make this business cash flow again, and to correctly position it to where they could get $500,000 in the mobile home park sale. So and with multiple sales of this mobile home park actually fell through. So not only did they have the business operating and managing the day-to-day activities of that, they were also trying to get buyers to list this, to be interested in it, and to actually do the showings of that mobile home park. So it was not just a small endeavor for them.
Your
Mr.
Honor,
Parker?
Your Honor, I try to be intuitive about these things. I'm not trying to pick on the co-executors of the estate. I'm simply question, and I think that's where my clients came from, is they question how you'd spend or why you would spend 75 hours a month, 60 to 75 hours a month on average with two separate people working to collect rent checks. I mean, again, they're the executors of an estate. I'm not trying to put words in their mouth. I understand that they chose to run it the way they chose to operate it as the co-executors of the estate. All I'm saying is that they knew full well that the court was going to look at this from a final counting perspective. They came up with a list of tasks. I'm not even challenging that the list of tasks were performed. I'm simply asking, they chose for whatever reason to spend 70 hours, 60 to 70 hours on average. And I just showed you 3 months of average time put together. I don't know why, but I'm not sure that they should have more than just and I think that's what my clients were going to say. Why, particularly all the money that gets separated here from the estate, it's just dissipating the benefit to the other beneficiaries. Why can't they just have $500 each per month with a set number of average hours, since we're not going to be able to go back and allocate what they spent all of their time doing, just the list of tasks? We won't know what they did 7.68 hours of work because they didn't write it down next to it to quantify it during that day. So would it be maybe more reasonable to say, here's $500 per month for each of these people that were working as the trustee beneficiaries? And oh, by the way, you're not really losing much because you're just increasing your 1/4 beneficiary share that you're going to get anyway. It's actually probably a tax advantage for them because they're going to have to count this as ordinary income, where the other one, they don't have any tax on it. So it's probably almost a wash. It just seems like instead of my client signing off on 30 hours or 40 hours from a non-contested standpoint, at least they didn't feel comfortable signing off that they weren't going to ask the court to at least look at what
And Your Honor,
justification.
I'm going to object again, because that absolutely misrepresents the information that's been provided to Mr. Parker. We specifically showed that it's 15 hours per work week is the estimated time that these co-executors were working in the business. It's not the abnormal time of when they first had to operate it, when they were first taking it over and isolating it in 1 month. But if you look at the 1.5 years that they were operating it, it comes up to roughly 15 hours a week.
530 days.
Yeah, and it's 530 days they operated this business.
Oh, I leave it to the court's discretion. I showed you 3 months, Your Honor, of every month looked at about the same. I could pull up other months where you would see that the fluctuation is. And Lisa, please, counsel, if you have other months that you want to share or something to controvert, I'm just going off of your exhibits. I'm just saying, I don't understand. Those were hours that they provided me. I just pulled up one of the hourly lists. There's no quantification of what they did during each of those hour time. There's just a bulk summary task list. That's not
Yeah.
how we bill, at least as
And Your
lawyers.
Honor, if you need, I'm sorry,
You're
if
right
you
about that,
need
Mr. Parker.
a
You're right
trial
about that.
to, if you need a trial to understand exactly the work and exactly the averages and the amount of hours worked and what tasks were accomplished, we would be happy to set it for trial so that you could hear proper testimony and actually have proper evidence in front of you to look at the 1.5 years of worth of work of these administrators. So we'd be happy to do that. However, just in preparing from the time when we had a valid settlement agreement without getting execution pages as the agreement, which Helen and Whitney waited until a best and final offer was expired to go ahead and accept it when we were 2 days before a mediation date, where we'd already worked up to go to mediation with a mediation statement, with preparing our trial exhibits, because our trial was set so soon that we had an absolute agreement in the valid settlement agreement of a set date for closing this estate. That wasn't our offer of settlement. I had to go back to my clients to see if they would honor their best and final, because it was actually an expired offer, which my clients agreed to. So it was their settlement offer that ended up being accepted in the valid settlement agreement. And part of that requirements that their clients wanted to have was that this estate would be closing on February 17th. as represented in the valid settlement agreement. And we could not do that unless there were the consents to doing the final accounting because of the significance of all of the work that's transpired and how long this estate has been opened up. But they didn't perform on that. They didn't provide their signed pages for us to actually,
The beneficiaries question every single task and hour logged.
like we would have expected to do. So they're causing a lot of additional work and expense to this estate to the tune of now we have an additional $2,000 by Jenica and me to keep litigating about things that should have been settled and agreed to in the final settlement.
Your Honor, I'm just working off of what counsel provided me. I'm not trying to challenge. Counsel provided me a statement that was prepared. The list here in 2025, this is what they told me at the bottom of their third page. Being asked to write down all activities performed as executor now because Austin, Helen, Whitney do not believe the amount of work it takes to manage the estate of Robert J. Corner. That leads me to believe that they tracked hours. They didn't create this list until after the fact. They created a list of items that were performed. I'm not trying to get into the metadata of when they created what they did in 2024 or 2023. I'm not trying to turn this into a matter of extreme litigation. I'm just trying to say, look, I'm just going off what they provided. I fully assumed that before they provided these documents, they provided me these documents in an email on the documents justifying the hours worked, okay, on February 7th, 2025.
Yep.
These documents were looked at and reviewed. I forwarded them to my client on February 11th. The scope and nature of our settlement discussions were not relative to the final accounting. They were relative simply to the final settlement that we agreed to was not the final accounting. That was to go to the judge. The final settlement was only supposed to be for what the spousal allowance and what the homestead allowance was for Helen. And so now we're talking about issues relative to final accounting. I'm not even saying we need a trial. I'm just saying, look at their exhibits. Their exhibit that they provided, the primary one that I'm most focused on here today were the hours calculations. This right here, which is what Kyle said apparently at the bottom that he prepared now. I'm not trying to challenge that. He just said he prepared that. And then here is a summary of the hours that Kyle said he worked and his expenses. This is the best I have. I have hours worked in August, and they range from 23 hours up to 63 hours, but that was an outlier in the middle of it in 24. But it seems like it was about 30 to 35 hours a month. And I'm simply questioning, why did we work 35 hours to manage a 20 unit mobile home park that was being positioned for sale? And if there were going to be that much management, why didn't just one person do it instead of two people doing 20 to 30 hours each? And I'm not saying that I understand the operations of a mobile home park, but it would have been a lot easier for me to justify to my clients if they would have put down, this is what I did this day. You know, these aren't my questions so much, Your Honor, as they are my clients saying, what did they do? I don't understand. They don't even live in El Dorado, Kansas. How did they spend 30 hours a month doing this?
So I'd like to have you take judicial notice of what was filed before this court on February 26th, 2025. And specifically the Exhibit B that shows the valid settlement agreement and also the emails showing that we had offer and acceptance of the valid settlement agreement.
Your Honor,
Parker,
if
you claim that the settlement agreement doesn't cover the issue which is currently before the court?
yes, Your
It
Honor.
actually,
Okay,
It-
Mr. Parker, I'm addressing Mr. Parker.
Yes, Your Honor. My clients agreed to a settlement agreement. They opposing counsel prepared it. I looked at the form. I sent it to my clients. They looked at it. They said, wait a minute here. This is above and beyond the settlement agreement that we agreed to, which is we don't want to agree to not contest the final accounting before the court. We agree to the settlement of the spousal allowance and the homestead allowance. because that's the only matter that my clients had a petition before this court. They didn't even have the ability to agree to a final accounting before the court because they didn't have standing to do that. They only had standing, particularly Helen, to agree to her spousal allowance and her homestead allowance. It's up to the court to determine what the final settlement is. So they agree to the spousal allowance and the homestead allowance, but they don't have the ability to negate the court's determination on a final accounting.
All right. That's currently before the court or not? Was this left open for determination by the court at final settlement?
So there is an agreement in the valid final settlement. It's a subsection G. It's the full estate distribution. The estate residue distributions will be made to the will beneficiaries and children of Robert J. Corner no later than April 1st, 2025, as long as the court orders approving the final settlement is received with the schedule of distribution. The co-executors agreed to complete the formal final accounting of the estate to be filed with the court on March 14th, 2025. So they did preserve their rights to review the final settlement. We will not be able to close, but we can do a trial so that the proper evidence and testimony can be heard on the amount of hours and work, and then the court can make its determination.
Which adds to the legal fees, which will be owed by the estate in this case.
Yes,
You
Your
are
Honor.
correct.
That's all we're doing is saying we just wanted the court to look. And quite frankly, Your Honor, again, I'm not trying to extend this. I'm trying to do the opposite. My clients don't, without presuming what evidence will be heard at trial, all they wanted to do was get to the final accounting with the court, and then the court to make a determination: are we going to pay these hours without linkage to what tasks were performed, or are we just going to come up with a blanket? Okay, if you say it's 15 hours a month at $35 at 35, if that's what the average should be, right? $15 or 15 hours a month times 35, that's $525 a month. Can we agree to a set fee for the administration since they didn't account for what they actually spent the hours doing in real time? Or do we have to go off of what they said? This is 31 hours this month, 64 hours this month. That's all I think that's all my clients are getting to in the final account.
Mr. Parker, this is not a new situation. The people that are making this claim for reimbursement have been managing this mobile home park for many, many months. And this was not suggested earlier that they be put on some sort of monthly salary for performing these services. I think they proceeded in good faith and conducted the business that the mobile home park needed. And I understand that there is a legitimate concern anytime that they do not itemize each and every time they intend to bill. Quite frankly, that's what I would expect from a lawyer,
right,
to justify their bill in a case. However, overall, what the court needs to determine is, are the fees that are being charged in this case reasonable given the scope of the work that they were asked to perform as fiduciaries in this case to manage this park? And the court will make a determination at this time that it does not have enough information before it to make that determination on a disputed issue. I don't think that these itemized statements, to the extent they exist and that you screen shared, were filed in the case, nor would I expect that they would be. But they are available and the court is going to need to review them. So the question is, who's going to provide those to me?
Your Honor, counsel, Lisa, would you prefer to do that? They're your exhibits. I don't want to presume to provide your items.
We would be happy to provide that with also the analysis that of the total hours using the time clock application that they use to track their actual hours performing
Expired offers and legal wrangling push costs even higher.
Work tasks for this business. We would be happy to provide all of the information that we provided earlier to Mr. Parker.
Okay, and that's really what I'm wanting. I want what he received from you.
Thank you, Your Honor. And we defer to whatever the court's decision is on what this is really, my clients just wanted the court to determine what they should or shouldn't be paid prior to the final settlement being approved. That's it, Your Honor.
We need this estate settled in a final fashion as soon as possible.
Yes, Your Honor. I don't think we need any.
Yes, and And typically at this point, we would also be showing our added attorney fees and legal expenses for preparing for the hearing today when we thought some of this was being handled with the valid settlement agreement and not getting those signed pages to actually properly demonstrate to the court we had a deal on resolving all of these spousal allowances. How would the judge like to review that matter, as we'll have, again, other legal fees in preparing the documentation to submit to the court for your review and perhaps even an additional hearing on it?
Well, email me your additional bill. Counsel, you will be obviously having to draft ultimately a journal entry of final settlement in this case. I know this may have already been roughed out and be ready for just to be adapted based on the court's eventual ruling on the fee issue, which is currently before the court. But send that to me and then copy in Mr. Parker. Just send that to me by email.
Thank you, Your Honor. I sincerely doubt that we'll need a hearing. Whatever the court's decision is off of the documents, I'm not trying to, I want this, just as the court said, this should be wrapped up as soon as possible.
Well, what is the hourly rate that I'm going to see on this additional billing?
So we're billing at $3.25 an hour with our paralegals at $100 an hour. I believe that's correct.
All right. Thank you for that information. I look forward to receiving it.
Thank you. And
well
we'll make
as
sure to do that with your assistant, Mandy. We'll email everything to her directly, or is there a different email address that you would like to send to?
Send it to Mandy. Mandy will get it to me.
Thank you, Your Honor.
Thank you,
All
Your
right.
Honor.
Is there anything else that we need to address as part of this hearing?
No, Your Honor, I will circulate the signature pages since now really the final accounting issues that the court's looking at to all my clients. I'll get fresh signature pages over to opposing counsel here by close of business Monday. Thank you, Your Honor.
Very well. All right. Well, I'll look forward to receiving these emailed materials, and the court will try to make a prompt decision in this matter so that we can reach eventual final closure of this estate in the very near future.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Then if there's nothing further at this time, the Kerner estate matter will be in recess. This meeting may be ended.
Court considers trial options. Tension reaches a critical point. Judges weigh evidence as the final accounting hangs in the balance.